Good evening, everyone. Welcome to IBIL's third COVID-related webinar. We thought it would be interesting to see across the UK profession or professions what's going on and the things we've thought about happening and what's happening within the profession, how much work's coming in, how much is not coming in, what sort of work, what sort of changes are happening, and what you yourselves are all doing to keep going in these rather strange times. You can say that COVID is producing more new ideas than God intended when he created the virus, because people invent things, and everybody in all these firms will have been inventing things. I gathered together a panel of stars, and I'm very grateful not one of them said no, and I didn't ask anybody else who said no. They're not going to get very long each, so the sooner I stop, the better, and I'm going to stop now and ask Willem to talk about the state of affairs in the world of patents.
Thank you very much, Sir Robin. I'm about to try and share my screen, but it's changed from what I thought I was going to share previously, which is stressing me out slightly because it was working. There it is. I found it. So hopefully my slides are visible. I'm assuming someone will shout out if they're not. And as you say, I'm going to focus for a few minutes on some thoughts about the impact here on the patent profession in particular. And that is based on some research that we did over the last 2 or 3 months, actually, to look at, in particular, the mantra you hear quite often that patenting, oh, it always makes it through recessions, don't worry about it. So we did a little bit of work, and I did promise a plug to RWS's Kostas Stefanides, who's an awesome expert on patent data, to look at the story of innovation on patenting as a reflection of innovation through previous crises, to try and get some lessons from that and to see whether we could extrapolate forwards. So I'll kick off with what I now call the big curve, because this is a lovely big piece of data, and it's basically patent applications and grants from 1930 pretty much to the present, give or take the publication window. The blue line is applications, and this is a reassuring curve. But as we'll see in a moment, you can get a lot of information out of this, not least, I would say, the boost that the international patent system brings in towards the 90s there, and much on top. But we focused in particular on some crises previously. So like I say, we're looking at patenting, which is, for mathematicians, proportional to innovation in some way, at least. It's not the whole story, but it's a useful story. And what we found from that map is that actually, a little bit like tree rings, you can see stories from it. Now, the resolution on the map here isn't enough that you can see what was going on in the 40s, but we have drilled down, and you can definitely see a dip there. But you can also see some interesting other steps. You can see a real flattening of the blue curve, focus on the blue curve, from around 1972, 1973, which is where the oil crisis hit. And you can see around 2008, there was another flattening, followed by a bit of a jump. And again, that was where the so-called Great Recession took place. But every time you see a flattening or a minor dip, you don't tend to see massive drops. And so there does seem to be a lot of truth behind the basic statement that patenting gets through recessions, and there's lots of theories why that is. The other interesting thing about this was some of the other artifacts that we weren't expecting. So you can see the blip around 2000, which is when the dot-com bubble burst, and also a flattening around 1987, which was the big crash as well. So it is fascinating how much is actually available, as I put it here, reading the runes from the IP story. This is on the website, the full article. There's two, in fact, but we looked at a few things, and some of the stories do resonate with what's happening again. And unfortunately, the most resonant story is the World War II story, because that's the one where really life was threatened. and it has a lot of parallels with what's going on now, legally as well, and policy-wise, which I'll come to in a moment. But we had a quick look at the hydrocarbons story, the petrochemicals story after World War II. Very quickly, the history is that because of the problems in Asia, the invasion of Asia, rubber became unavailable. So the economies had to find new ways really rapidly to find a way around that. And the way they did it was to do patent pooling and a lot of collaboration. And so what you see with the blue curve here in particular is the increase and increase and increase, a flattening around the war period of 42, 43, etc. But then it starts kicking off. And what happened really was that there was huge activity driven by requirement and necessity during the war years, and collaboration and patent pooling, as I say. And then following on from that, the boost that are given to innovation gave rise to a continuing growth. And as you can see, that curve's on the upward slope towards the 50s there. And what this kind of suggested is that what happens in crises is that certain areas of innovation are accelerated. You don't necessarily see brand new technologies being created. What you see is society finding technologies that had been lounging around waiting for a use. Other examples, by the way, include things like radar, jet engines, nuclear technology from World War II, and for example, from the oil crisis, there's been a lot of work on solar and what we now call renewables. But it was the kickstart of a crisis that really got it going, and that's been absolutely fascinating. So crisis seems to provide this platform and infrastructure for future growth. And there are more stories. I just wanted to pick out one in a short time. And the other thing that's very interesting from all of that is the policy side of it as well. So your fantastic seminar a few weeks ago, which talked about the open patent pledge and some of the collaborations and activities going on between pharma companies, was a really fascinating insight. And again, an echo of what we've seen before, either a private or public-private collaborations to deal with these upheavals that we have to face. And it's reassuring to see that, again, that's happening now. History is repeating itself. But this time round, it is educated and helped a little bit by the fact that we've been through things like this before. A little bit like the financial easing that we've seen going on to deal with the inevitable recession. The world moved incredibly quickly and effectively. And this is because we do learn, believe it or not, we do seem to learn from what happens before. And the way that's showing itself here is, firstly, the behavior is repeating itself, as I say, of collaboration. But secondly, we are seeing what seems to be a pretty rapid policy shift. Obviously, the long-term IP policy is long-term reward for innovation, et cetera, but here, people are putting that to one side in the short term. And what instead we're seeing is this working together kind of vibe that you're going on. Now, you could argue that some of that is because any other behavior is going to get you in all kinds of trouble with the media and your customers. And that's possibly true, but I never have a problem with public opinion driving behavior. It seems a good thing in many ways. But also, it feels like the previous policy changes and things that were put in place after previous crises are actually helping with the right kind of behavior. And a great example of that is compulsory licensing. What we're seeing is that that's there, but it's not being used because it's just not very attractive to the market at all. They would rather collaborate. They would rather give out the royalty-free pledges and sharing pledges that are going on, because frankly, because of the measures that were put in place from previous crises, the alternative actually isn't very attractive. And for me, that is actually a triumph of learning from our errors and really taking some really positive steps. But what we can expect to see in the longer term is a shift back to the obvious, more normal approach to royalty-based or indeed litigation-based use of IP, hopefully lots of royalty-based. And that's, again, a story that we've seen from previous crises as well. There's a whole area of history that I've touched on, I didn't realize after the Second World War. The US, huge range of policy changes to deal with the fact that lots of government investment had gone into IP and how to make sure that the rewards of that were shared equally and fairly. So the policy, and we can learn from that history, and it is a good story. We have actually, so far, it seems, done the right. Our behavior is not surprising, but it's facilitated by the infrastructure, which is good news. So just quickly, in relation to what does this mean for the patent profession, and I'm really focusing on the patent attorney profession here, because we have experts in other areas following on. In terms of IPO and EPO trends, what's going on there? The IPO indicates that patent applications are as forecast. Search and examination requests are very slightly down. Trademarks, there's an immediate, quite significant drop in filings, but that's not only leapt back up, but in fact is ahead of projections now. So I have no idea why. Interesting real-time information from the IPO. Ditto the EPO, productivity is high. There's been a slight drop in the machine manufacturing, but generally speaking, again, constant behavior. However, they do expect some potential changes of behavior in the second half. And of course, we're all very early in the data here. It's difficult to know exactly what's going to happen, but so far, the news seems quite healthy. Similarly, talking to peers in the profession, nothing spectacular is happening, but things seem to be holding up. Looking at the stories we've learned from previous crises, I think we can see a leap in healthcare. IP, not at all surprising, but perhaps more surprising, I think it's very likely that we'll see, thank you, connectivity increasing. We're all on Zoom right now. We're going to see lots more of that. My little theory is that in terms of accelerating a technology, the internet has come of age. That's a nice controversial one. It was there, of course, before and very useful, but we've never had to rely on it like this before. And it's now that we've really realized just how essential it is to human life. And finally, that the UK, it's already a global center of excellence. I think the world is opening up. Geography is diminishing against all of this. And I think the UK has a global reputation. For me, the key area is that we look at the changes that have happened and we've become a genuinely global profession. And there's a huge possibility there. Thank you.
Thank you, Gwilym. Interesting story. Catherine, you're going to focus a bit more on trademarks. We've got two Catherines, Catherine Wolf. What's the story from Bolt, Wade and Tennant?
Thank you very much, Sir Robin. Now my attempt to share the screen. There, I believe, yes, I can see it reflected in Gwilym's glasses. That's absolutely marvelous. Hello, yes, I'm Catherine Wolf, and I'm here to talk on the trademark side. The flyer for this seminar said, will any decrease in filings of trademarks, designs, etc. be offset by an increase in IP litigation and transactional work? Is the patent attorney adage that patents are recession-proof likely to hold true? Well, it's absolutely true that people say that in the good times, a business will file more than it sues because all eyes are on the horizon. But in bad times, it sues more than it files because all eyes are on the ground. So in light of that, here is an interesting slide. The UK Trademark Registry in May 2020 received the largest ever number of domestic applications in a month, just over 9,500. And June, I believe, was similar. And I don't think this means that we must be in good times, but it also doesn't mean that we're in bad times. What we are in here is strange times. This is an unequal virus, as the politicians keep saying. It has different effects in different ways. Some of my clients have had an incredible increase in business. The bricks and mortar retail sector was of course hit by the drop in footfall, but online retail expanded. DIY has flourished. Speaking just for my firm on trademarks, we've not had that many instructions to stop cases. But we have had inquiries about delaying and postponing. For example, how long is a grace period on a renewal? How much is the extra official fee if we use that grace? So clearly there are plans for a U-curve or a V-curve here, rather than the dreaded L-curve. My guess is that when the graph can be drawn, which of course will be with hindsight, it will look like a stretched tick shape. If nothing else happens to send us off kilter, let us not mention Brexit. However, what we don't know is what the time frame will be to make that shape. What we do know is that lockdown has made changes in working practices, some temporary, some permanent. Some happened very quickly. Again, speaking for Bolt, Wade, Tennant, we went into home working for almost all staff between the 16th and 17th of March. So basically overnight, we went from 7 offices to over 200 offices. We had a huge advantage. We had the infrastructure. We already set up with 4 offices in England, 2 in Germany, 1 in Spain. So everything already had to be online for us. It was just a question of scaling that up massively. And similarly, if you're a sole practitioner who's able to continue to use your office, then your internal office working day might not have changed very much. However, if you were a small group in a paper-based office, though, it would have meant much more of a challenge, perhaps involving a skeleton crew or a staff rota. It's an unequal virus. So how this changes the profession, I think, is an application of Hooke's law of elasticity, thanks to the Encyclopedia Britannica. A few people working at home, regularly or occasionally, doesn't affect everything. But when everyone is working at home, that makes a permanent stretch such that you don't return to the original position. A typical professional office of 2019 would generally have around 80 to 90% of staff on site at any one time. That in 2021 is going to look like an exceptionally full office. The term of working at home, when I started in the 1990s, carried a stigma. People used air quotes. It meant swanning around. That stigma has entirely gone. The Outlook green blob shows very well what you are doing. It also changes presenteeism. No one now gets kudos for having a long day at the office. That marker of dedication has gone. And you can do a lot with Zoom and Skype, like what we're doing now. At Bolts, we've interviewed over Zoom and Skype, we've made offices over Zoom and Skype, hired over Zoom and Skype, and we even had someone starting over lockdown, which meant virtual onboarding. This is probably the only time in my life I will use those words, virtual onboarding. I share them with you. But to be Darwinian, offices are the default natural environment. It is a different place to be, and it's good to be together. You do lose something by this remote working. For a trademark attorney who wanders the office every day saying, what do you think about this one? It really isn't quite the same. Even with online coffee breaks as a kind of artificial substitute for naturally occurring informal conversation, there's no overhearing. We've lost percolation. That's a term of art now, percolation. For example, on the social side, which matters enormously. Someone in my office is pregnant, and I was very amazed when somebody else turned out not to know. But why would she have known? You can't tell from talking heads. And of course, you're not going to call everyone individually with your news. You tell loads of people in a Zoom mosaic and you think it'll disseminate because in a physical office, that would have got round everyone in 10 seconds flat. But now it doesn't reach everyone in the virtual offices, even within 10 days. And of course, people feel more isolated than before because they didn't know and other people did know. So following that through, I think this isn't the end of the physical office, but its environment is going to change. It's going to be emptier. From this time forwards, we can expect many more people to work at home 1 day a week, perhaps more. I think that will affect the home as well as the office. A non-daily commute can be much longer than a daily commute. That makes it possible to live much further away from the office. That's going to mean we have a lot more geographical diversity in our offices. And it has other benefits too for diversity. Your home is adapted to you. Public transport is never adapted to you personally, and it can take a little while for an office to adjust perfectly. Virtual working removes the mobility issues for the commute, and so for those diversity aspects, it has to be good. It's also very good for some forms of neurodiversity. If you have face blindness, like the late Oliver Sacks, it's wonderful to be communicating with people when their names are right there in front of you all the time. But again, it is an unequal virus. Working at home is wonderful if you have a book-lined study and a place to think. If you're sharing a crowded home with housemates or family, or with bad internet, or even with bad housemates or bad family, it is a different challenge, and you're going to want to be back in the office as soon as possible. Compared to so many professions, we trademark people had a few lucky breaks on the lockdown scene. This is because we stand before 3 main bodies, and all of them have a very significant virtual capacity or e-embodiment. Not everywhere. I mentioned in passing the Company Names Tribunal, which is rather niche, and one that is paper-based at the moment. So that's in a pause at the moment. And though many trademark attorneys regularly appear before IPEC and the High Court, that scene is very brilliantly represented here by my colleagues, so I'm just going to stick with the IPOs. First, you've got Wipo in Geneva. Wipo is the most E. It's so it turned off its Madrid Protocol fax machine on the 1st of April 2018 for trademarks. On the 1st of January 2019, it turned off its Hague fax machine for designs. And that is a repeal of Section 203 of the Administrative Instructions. I've got the note there. Second, there's the EU IPO in Alicante. Slightly against its usual custom, it's recently had some real physical hearings, like the Monopoly case. But apart from those rare exceptions, it really wants to be a totally e-system, based on its user area and with online forms. Similarly, it's been moving away fast from fax machines. It went into interruption for COVID-19, and that was postponed once, but not twice. Third and best, there is the UK IPO, mainly but not only in Newport. Now, the IPO is not a no-paper registry, and fax has been a very important part of its life, though it does an awful lot by email and online forms, and it now has an e-fax mechanism called paper form contingency, which rather indicates that it's planning to be temporary, or it would have had a different name. In terms of personal presence, it's had hearings by telephone and video link for many years, though an inter-parties hearing often has an in-person hearing officer, especially when it's an appeal to the appointed person. And I think the IPO handled interruption best of all the officers, because right from the start, it undertook to give 2 weeks' notice of resumption. Many will remember the afternoon of Friday the 15th of May, and the rumour that, of course, the EU IPO couldn't possibly be reopening on the Monday. Of course, it would be postponed again, but it did, and some people were caught on the hop, even though the EU IPO did kindly confirm that Corona counted as an exceptional circumstance for extensions. Here is my last slide. The registries were fairly well set up for when lockdown hit, and what about the job itself? That is a question of perspective. Here are 8 opinions, all of them valid. I have held all of them over the last 3 months, and the last one's quite interesting. On my last day in the office, I made sure to take home some letterhead paper and some envelopes. Because when you have to write someone a serious letter about a trademark, you want all those psychological trappings of authority. You want the formal letterhead, well laid out correspondence, a bold signature at the bottom. It all helps to create a certain effect. And I am very glad I have the paper in my box, but in fact, I haven't used it yet. Instead, my excellent secretary turns the letter into a PDF and it goes out as an attachment. And in some ways, that is actually better than post because it makes it so much easier for the recipient to reply. And when you think about it, the main point is to get a response. Emails are very, very good for getting responses. So finally, my questions. If you were used to a binary life where the place you work is your office and home is the place which is not your office, then quite literally, can you ever go home again? And I'll leave you with that. If I can stop sharing. Didn't practice that bit.
There we are. I'm back again. Well, we're going to try and address some of your questions which you sent in, and you can please keep sending questions in on the Q&A facility. And we now move on to the other Catherine, one with a K. Unmute.
There we go. Yes. Thank you very much, Robin. Well, however much you might have ticked and cursed over your broadband speeds over the last couple of months, just think back 10 years ago and what it would have been like. Ofcom reported then that the average download speeds were about 5 megabytes per second. This year it reports that they're about 64 megabytes per second, more than 100% increase. I suggest we wouldn't have coped if this had hit us 10 years ago. Our business would have ground to a halt. Nevertheless, it's been something of a seismic shock for all of us to be sent home overnight in March. And it was not something that we had legislated for in our disaster recovery plan. If our building had been knocked out, we were going to rely on other premises in central London to house all our staff. But that wasn't going to happen. So what have we learned? Well, what I've just got here is a congeries of thoughts And I'm going to start with our IT systems. Our preconceptions about how things had to be done basically had to be dumped overnight. We found that many of our internal systems were reliant upon us being in the office and somebody being able to sign a piece of paper to make something happen. And although at first email replaced it, it has now been automated, a huge task for our IT department and a huge benefit to the firm going forward. And everyone, and I do mean everyone, had to get up the curve in how to use our tech, which proved a challenge for some of our lawyers and also for our long-suffering IT staff. But we have found that people can manage. They can manage without their PA or their trainee working a few feet away from them. And they can manage without a printer. Indeed, very little printing has been done over the last few months, meaning that on the litigation side, we have had to come up to speed very quickly on how to generate e-bundles. And do be warned, it does take a little bit longer than producing standard bundles, so do give yourself an extra day or two, particularly to sort out bookmarks. And M&A closings can also be done online. Indeed, one of my corporate partners, who he admits himself would never have engaged with doing so beforehand, has now done an M&A closing online and has said he would never go back to doing it in any other way. But on the downside, because everybody was slightly off balance, it has been a hacker's paradise, and we have seen a vast increase in phishing attacks and scams of all sorts. But we are lucky to date that everybody has remained alert and we haven't suffered. Now, what about lessons learned on the client side? Well, interest amongst our lawyers in legal tech that they can offer to our clients has absolutely soared over the last few months, and our clients appear to be much more open to the use of legal tech and online platforms, and in some cases are demanding it. The problem in installing these systems in the past has always been that although the technology was there, it can be just a little bit boring and a little bit of a challenge to learn how to use it because it changes the way that you work. And frankly, it was too easy to get together for a meeting. But now people are open to change and much more interested in the tools that can help them work remotely. And we have found that the tech does not need to be particularly snazzy or highly sophisticated. A simple system built on, for example, HiQ to generate reminders, allocate tasks and share documents can, with thought given to its design, be extremely effective. And in future, I believe that uptake will only accelerate as clients see how these platforms can drive better communication as well as efficiencies. So we need to be ready, or rather, we need to be even more ready than before for the challenges this will bring, including the increased rise in the dreaded legal ops person or project manager, which will eventually shake up established relationships and challenge the use of the hourly rate as never before. And turning now to internal matters, for a number of years, the younger associates have been pressing for agile working, and it has now been shown to work. So even the oldest of the dinosaurs has been converted. So it's no real insight to say that we will not be going back to the 9 to 5 everyone in the office environment. Also, those who worked at home before lockdown found that when you were not physically in the room where most of the others were, it was really difficult to follow a meeting. Now when we're all in the same virtual room, it's much more of a level playing field and brings what I think is a real democratization to the meeting. And I think it's also driving better behavior, encouraging participants to arrive on time. So long may that last. And everyone is much more used to hopping on a video call, whereas it might have taken years to meet a new client. We're meeting them virtually during our first call. And similarly, with online pitches, we can now take along lots more people and introduce the juniors and bring in non-legal people to those pitches. So for example, the accounts managers can come with us because there's no need to worry about travel costs and time spent out of the office. So all those, I think, are extremely positive things that that are coming out of the present lockdown. But looking at some of the negatives, To date, we're lucky that the work has held up, but what will it mean to relationship building and meeting new clients once the fun of virtual social events have worn off? And what about litigation going forward? Immediately after the financial crisis of 2007, our revenues in Bird and Bird went up, and they went up again in 2008. Indeed, it was not until 3 years later that we saw a dip. We attributed that at the time to the fact that litigation and big projects were on a long lead time, and so it takes large corporates quite a long time to cut costs and put the brakes on. Now, Lisa, if we could have my slide, and this is my one and only slide. Thank you very much. On this slide, I have looked at the figures for filing IP cases in the High Court and IPEC over the last 6 months, January to June 2002, and compared that with the previous 6 months, January to June 2019. As you can see, last year, the numbers were generally between 30 and 35 cases. That's all IP cases filed in each month. We're now, unfortunately, going from a peak in January on a long slide, and it looks as if we may be in for a bumpy ride in a year or two's time. Just before this, we started with the presentations. Robin asked me what was going on underneath those figures. Well, the Patents Court, the figures jump about quite a bit, but the filings in the Patents Court are responsible for that upward tick in May 2020. But otherwise, the general IP cases that are filed in the High Court really have almost disappeared without trace, and IPEC are also down very considerably. And this is in the light of the fact that we have to prepare for the next potential shock of the system coming down the line in the form of Brexit. And indeed, some of our contingency planning for that will have to be torn up in the light of the new way we are now working. But leaving Brexit aside and not wanting to end on a downbeat note, I wanted to make 3 last points. First of all, I have been enormously impressed and indeed humbled by how our team has held together over the last 3.5 months. Some have been living alone and some working under very difficult circumstances. And we must not slip in our efforts to keep the teams together now that some of our people will be going back into the office as of next Monday. We also have to maintain our talent, both at the junior end and coming into the profession. I've seen in the past the damage that can be done in having years when we have not taken on sufficient members during the downturn. And at Bird and Bird, we are continuing with our summer student program, and our trainees who plan to join us in September will all be doing so. This has required an enormous effort to organise, but in my view, it's really justified. And what we don't want when we go back into the office is sort of what I would call muscle memory kicking in and people going back to bad habits. Catherine talked about Hooke's law of going beyond the elastic limit of the spring. I'm concerned that we haven't pushed enough people over that point. So for just one little example I've got, can we maintain our near zero printing when we go back to work? Although it would be very tempting to pocket the savings, what I would like to do instead is to invest in better tech. Otherwise, I think it would be a missed opportunity. And that is how I would like to see these last 3 months, a spur to a change in the way we work. Otherwise, perhaps we would have been too complacent to contemplate such change. And I think it is now upon us. So thank you very much.
Thanks, Catherine. Fascinating. I'm very glad you're taking all your students on, all your trainees. You won't regret it. On the whole, looking back, the profession which has been worst at taking on trainees are the patent attorneys. If they'd taken them on when we joined the European Patent Convention in large numbers, the patent profession in this country would be at least half as big again, maybe even bigger. And what should happen? Take them on. It's an investment for your life as well. Right. Iona, how's the bar doing?
Thanks, Sir Robin. Well, from my perspective as an IP barrister, if I start talking about the courts first, the business and property courts, in particular the High Court, have transitioned to remote hearings amazingly well. The judges and the court staff have not stopped for breath and managed to get the whole remote court system up and running incredibly quickly and smoothly, and it's been functioning well for about 3 months now. There have been some adjournments, but not many. For example, a large FRAN trial was adjourned at the beginning of the lockdown period, but this appears partly to have been for other additional reasons outside COVID, to do with the fact that there is a Supreme Court judgment pending, which would impact how the trial was conducted. Most hearings appear to be being carried out fully remotely, with all participants in different locations. There have also been some hybrid hearings with some participants in court and some watching and participating from other locations. In terms of getting hearings on, normal non-urgent hearings in the High Court, such as case management conferences and applications, appear to be being listed in the usual time frame before lockdown. Say a half-day hearing in the High Court is usually being listed within about 4 to 6 weeks. A master's appointment maybe 6 to 8 weeks. And likewise, I think it's really important to emphasise that the UK IPO hearing system has transitioned to full remote hearings amazingly well and is also functioning incredibly smoothly. As we all know, with IP disputes, the speed of the litigation process is very important, and the fact that our courts and tribunal hearing systems have kept the show on the road so well has allowed ongoing disputes to be managed in a really timely manner. And the fact that the business and property courts and the UK IPO have been able to respond in this way and keep both systems functioning at such a professional level is a real success story for the IP courts and tribunal system. To my mind, the most recent and important development for IP court users to be aware of is the recent speech given by Sir Geoffrey Voss, who is the Chancellor, who has the responsibility for the conduct of the business and property courts. This speech was given to the Chancery Bar Association a few weeks ago. In this speech, Sir Geoffrey Voss made clear that in his view, the remote hearings are working extremely well, and that in many cases they had considerable costs and time savings and so were advantageous. Therefore, it was his view that after COVID, the crisis has subsided, remote hearings and hybrid hearings are here to stay as a normal part of the litigation process in the business and property courts. His view was that remote or hybrid hearings should be possible options in all hearings going forward. Further, he proposed one possible rule would be that prima facie, all interim hearings, such as case management conferences or applications, where very substantive decisions were not going to be made, should be dealt with remotely, unless there was a good reason not to do so. So it's quite clear that there will need to be a debate in the future as to how widely remote hearings will be used and in what circumstances. But it does appear that remote hearings and hybrid hearings are here to stay and will be part of the possible options going forward in the litigation process. For my part, I've certainly had some very positive experiences with remote hearings and some surprising positive developments. The first positive development that I had not predicted would occur is that there has been a significant increase in client engagement in hearings due to the remote format, particularly where there are international clients involved. As it's so easy for clients to watch the hearing from their home or their workspace on their laptop, many more clients are watching hearings. And this is a welcome development for lots of reasons. First, it means that clients are aware in real time of how a hearing is going and progressing and what it has been decided by the court if it's an instant decision. And this means the clients are much more engaged with the process, which has been really helpful for everybody. I mean, it speeds up the communication process greatly. Second, it also means that clients see firsthand how judges are reacting to particular issues, which allows them to understand the process well and helps them to appreciate what instructions are required and why particular issues are important. And in my view, this increased engagement is really helping with clients providing more detailed and focused instructions. Thirdly, the wider exposure and accessibility of the court process is also a great advertisement for the UK court and tribunal system, and demonstrates the detailed and careful way that justice is dispensed, and also shows how flexible and up-to-date the UK systems have been. A lot of international arbitrations have been using remote hearings for quite a long time now, and now that the UK court system has embraced this technology and can offer this remote hearing facility as another option, it means that remote hearings are no longer the preserve of the international arbitration sphere only. The second positive point I wanted to mention is the manner in which one can get instructions during a remote hearing. I had been quite concerned before I started doing remote hearings how I was actually going to get my instructions from my solicitors and agents and clients during the hearings while I was making submissions. However, so far I haven't actually found this to be a problem at all. With the use of email and WhatsApp groups, it's feasible to get instructions and feedback quite quickly and clearly. These instructions, you can review them as the submissions are ongoing. I mean, perhaps sometimes you take a pause at the end of a point of your submissions, review your instructions and make any extra comments that are necessary. Again, also some clients like the direct link with counsel, the person who's actually making the submissions while it's going on. They're not feeling that they have to pass notes up a whole chain of different people sitting in the courtroom to get the point across. And likewise with the group email, sometimes my solicitors can deal with a query that's arisen there and I don't need to address it at all, and give the client any reassurance that the client needs at that time. Another positive, obviously, with remote hearings is it does allow for different businesses who are in different parts of the UK, say London, Manchester or Liverpool. It offers a solution to dealing with where a hearing should take place. And I've certainly pre-COVID had quite a few disputes in court about where a hearing should actually physically happen. And this does offer a resolution. It's also important because for businesses, one of the real drains of litigation, apart from the costs, is the loss of business time that ends up having to be spent on the litigation process. Providing the remote hearing option is one way of helping to keep key workers and directors' time to a minimum, that they actually have to be involved with the hearing process and dealing with the hearing itself. There's of course issues for litigants in person. If they don't have the technology available to them, remote hearings are not going to be an option. However, certainly the issue of travel costs can actually be quite prohibitive with litigants in person. So again, the remote hearing is giving them another option. I mean, Catherine made the point about video conferencing. We've all had to embrace it. And that, I think, has been a really good thing because it means we've all had to do it. And now we've seen it really is a viable alternative to in-person meetings. I mean, sometimes, yes, a face-to-face meeting might be better. But what we've learned is in many cases, video conferences are good enough to get the instructions that we need and the information that we need. And also with regards to education and training, the use of these remote webinars, I think, has increased access and participation greatly. For example, the speech given by Sir Geoffrey Voss to the Chancery Bar Association that I mentioned earlier, there were over 300 people listening to that webinar. And if that had been a live speech given to the Chancery Bar Association, we would never have had so many people watching at the time. As for litigation generally and business, the effects of COVID on business, I think we really are in extraordinary times. And so the effects that are occurring are very uneven, as Catherine Wolf said, for different clients. I'm interested in the figures that Catherine's put up on screen about the reduction in new claims being instigated. And I would say anecdotally that reflects, particularly with work outside the patent sphere, I would say that sort of reduction in new cases being issued probably sounds about right. I don't think there's one simple reason for this, but I would say that one point that I've noticed at the moment with clients, particularly with brands and rights holders, they are being cautious at the moment about taking actions that could cause any sort of reputational damage. We are living in extraordinarily heightened times at the moment. We're living through an international crisis, and the public message and mood is very much about we should all be trying to pull together to save lives and to keep our economy on track. Therefore, brands and rights holders, particularly those who are consumer facing, are very concerned about reputational damage and making sure their actions are in step with the public mood. They are aware that what could be seen as aggressive litigation may not be perceived positively by consumers in the current climate. Also, as Catherine has mentioned, different areas of trade are being affected very differently. I mean, some businesses and clients have been incredibly busy because lockdown has had a very positive effect on their business. It's increased the demand for their services and products. You know, if you're involved in home exercise equipment or online food retail or homewares or DIY, in these businesses, the demand has gone through the roof. And so what they're concentrating on is radically expanding their possible supply chain and capacity and their delivery capacity. They simply don't have time to give instructions to lawyers at the moment, but that's for positive reasons. However, there are obviously other clients who are literally fighting for their business's survival. And again, they are not going to be talking to their IP lawyers about giving instructions on potentially new cases. I've also heard of some businesses who've sort of set up blanket spending freezes while they see how the current situation develops, and that they are, to some extent, they've gone into hibernation mode, and they will emerge at some point when they feel it's safe to do so, to start developing and progressing their business more actively. I do think these extraordinary times will settle down and things will start to get more routine. And the fact that our IP court and tribunals have reacted so well and so quickly to keep our systems on track and to provide new ways of holding hearings is of real benefit to us all. And it's allowed our current system to be nimble and effective as the current situation develops and changes. And those are my thoughts. So back to you, Robin.
Thanks, Iona. I'm sure you said all those things about how nice the courts are only just because you want to pander to Colin, who comes on next, and of course is a judge and is therefore both good and beautiful.
That's it, the introduction. Well, thank you very much, Robin, for that. The worst thing about this blessed video technology is that it makes my skin look really pink, and I'm very vain. I don't like the fact that we all sit there having to look at pictures of ourselves, and for some reason the computer always makes me look even pinker than I am in practice. I know I'm pink anyway, but I don't think I'm quite that pink. I was going to say, really cover very similar ground to the ground that Iona covered. I mean, as Iona said, Sir Geoffrey Voss, the Chancellor, spoke to the Chancery Bar Association and really laid out his vision about where things were going to go. But before I get to that, I think it's worth maybe tracking back a little. The way we've tried to look at the effect of COVID on the courts, and I mean the business and property courts, the intellectual property courts. When it all started, we started thinking about what we were pleased to call the short term, the medium term, and the long term. And sitting in a discussion, as I was in sort of it was about the 20th, wasn't it, when it all started, the 20th of March. We thought the short term was going to be maybe 3 weeks or maybe 5 weeks or something. The medium term would be a week or two while we all got back into the office, and the long term was going to start round about the middle of May, maybe the beginning of June. And that was the timescale we were thinking about. So of course, that's not proved to be the case at all. I think it's fair to say we're not in the short term anymore. We're now in what I would call the medium term. The short term was we had to get online, and the courts in the Rolls building worked their absolute socks off, and the staff in particular deserve an enormous amount of credit for this. to get the courts to be able to sit online. There were some adjournments, as Iona said, but the number of cases that were adjourned is really very small. And we've managed to keep the vast majority of the business and property courts going by remote hearings. And that's, it's quite something. Interesting lessons have come out of that. I think one of the things which maybe hasn't been mentioned, but I think is an important lesson from this, is lawyers generally, and I'm as bad as any, could be described as hyper-perfectionists. There's a sort of hyper-perfectionism about the law, and that applies to bundles. I remember a judge when they first went on the bench who issued in about 1992 or 93 advice on bundling. One Mr. Justice Jacob. I think it was one of the first things that was ever issued from the Patents Court, which contained R. Jacob as one of the judges. And that view that everything has to be absolutely perfect is something which everyone has. And the thing that you learn so fast with this technology is that you just need to get over yourself a bit and be a bit more tolerant. And we've all done it. You know, we have these online hearings where the video works most of the time, but occasionally people freeze. That doesn't matter, no one bothers anymore. People forget to unmute their microphones, but everyone shouts at them that they've forgotten to unmute their microphones, and the hearing continues. And it's all sorts of things like that. And I think there's really quite a profound point, without getting too strange about it in there, that the legal profession has realized that actually we don't need to be quite so prissy as we used to be. And things can be done, old things can be done in new ways, which people didn't think were possible. And it really is, I really hope, and I'm sure, we will keep that lesson close to our thinking, not just about video hearings and that kind of thing, but about all sorts of aspects of civil justice. Because I think it's an important lesson to learn, because we've demonstrated that it can be done. But that was the short term, where everything was, more or less everything was remote. Actually, there were some physical hearings in the Rolls building, very few because they weren't necessary, but it was always possible to do that if it was really necessary. And committals was an example where it was thought that it should be. The medium term probably started a few weeks ago, and that means that there are now, I think it's now a third of the courts in the Rolls building are available to be used for a hearing. They're not all being used at the moment, but they're there to be used, and that's used in a socially distanced way. And the staff again have been magnificent in setting up the Rolls building to accommodate people and to have, you know, hand sanitizers everywhere, all that sort of thing, labeling and the like. And we are now doing hybrid hearings in the Rolls building. There's the high-profile Barclays case, which has been in the news a fair bit. That's not an IP case, but it's in the Rolls building. There's a case in the Chancery Division that's been in the Rolls building. I think Mr. Justice Roth is also doing one at the moment. So it's beginning to happen, and I think it's very likely that over the next weeks and months, that number will increase. I mean, obviously there's the summer vacation, which will affect the High Court, but that aside, that's the direction of travel. I'm going to do a hybrid patent trial in July, where counsel and the judge, and I think I'm right in saying, although I can't remember now, some of the witnesses will be physically in the building, but some of the witnesses I know will definitely be on the video link. And that's not really different from what we've been doing in the Patents Court for 25 years. We've had video witnesses for a very, very long time, but doing it in this new way is something we're learning how to do. So that's where we are with the medium term. But that medium term, you know as well as I do, but my guess is that we'll still be doing what I've been calling the medium term till Christmas. I don't know, but I think it's pretty likely. So in the autumn we will be having remote hearings because of COVID. We'll be having hybrid hearings in the Rolls building because we can, and some won't be hybrid. Some will be totally physical because there'll be nobody on a video. But I suspect most of them will involve some aspect of video conferencing, and that's the way it will work. What other implications are there from that? Well, Catherine said something which resonated with me about I've forgotten the word, neurodiversity. I think that was the word you used, and that was something that really resonated with me. I was doing a video hearing in the applications court. Feels like a lifetime ago. It was probably about 6 weeks ago or something. And one of the litigants in person was in the court, in the remote hearing, and there was a discussion about oh, that's right. She was actually a Mackenzie friend. It wasn't her. It was another person she was with. And the question was whether I should allow her to speak on behalf of the person she was with. And the discussion went on. And what emerged is that the individuals, and I don't want to put this in, I want to put this in exactly the right way. They were what we sometimes describe as being on the spectrum. They weren't, I'm sure they weren't anything like you'd say autistic, but they were those people with that sort of characteristic. And what the person explained to me was that they found the remote hearing much easier than a physical hearing. So while there's an assumption that people make that litigants in person will all want to have physical hearings, but that really brought me up to think that actually there is a class of individuals with a perfect right to appear in court and to represent themselves if they wish, or to be represented, who actually find, in quite a profound way, they find the remote hearing approach better and easier to deal with than a physical hearing. And that's something which I think we really mustn't forget when we go into the future. What will the future be? Well, the Chancellor's already explained this, as Iona has told you. It's fair to say the courts, I can say the courts think, it's not for me to, I can't personalize it in that way, but it's pretty obvious that we've learned that remote hearings can be done. And we've learned that they should be done in many, many cases where we were never doing any in the past. And that lesson has been picked up, and but what we do need to do is think through and learn which cases are the right ones to do that way and which are not. And we're nowhere near the end of that process of working out that question. And the Chancellor's thinking when he made his speech which obviously reflects the position as we're thinking about it now, is to say, well, we need to have some sort of rules of some sort. So maybe a default that case management conferences, applications which don't involve witnesses will be expected to be remote, but they don't have to be. And one might think maybe litigants in person should have the ability to effectively have a trump card and say that if they wish it to be a physical hearing, then it should be, without them having to justify it. Maybe not. Another dimension to all of this is equality of arms. One of the things which is very clear at the moment is that, of course, we're all working from home, more or less. Everyone is doing it this way. And it's worked because we're all in the same boat. Perhaps Catherine Wolf's very legitimate point about it being an unequal virus. And that won't happen forever, hopefully, heaven help us. So there will come a time when that's not the case. And that starts raising some more tricky issues. What happens if one counsel wants to be remote and the other wants to be present physically? And one simple thought is to say, well, the equivalent representatives ought to be in the equivalent manner. So if one person is remote, the other person needs to be remote, or something of that kind. And you can imagine exceptions to that maybe people are prepared to accept a situation in which one is and one isn't for good reasons, and so be it. But that's one thought. But these things do need to be thought about. And it will take a while to work all that out. Participation in hearings, that's something that you've heard already from others, and I'll just mention it as well myself. It's really quite something. One of the things that you have, of course, we all have with these technologies, is you can look on a little window on your screen and it'll tell you how many people are in the video call. Now, of course, when I'm sitting in court, all I have to do is look up and I can see how many people are in my court. But I'll tell you this, the vast majority of cases I've done remotely for the last 3 months have had more people in them than the vast majority of cases I've ever done in the patents court. The number of people participating is much, much higher. And as I think Iona said, people are participating internationally. It's pretty obvious that there are more clients in the calls. I think the press are able to attend hearings more than they did. You see that happening. And the ability to have that sort of participation is also a huge advantage. The other point that was also made, which again I've seen, is litigants outside London. It's the remote hearing approach, or the hybrid hearing approach, means that the court isn't so shackled to London as it used to be, and people from outside the city can come and attend the court without having to get on the train. And that's another very significant advantage, which we need to learn. Actually, how you do hybrid hearings, I think, is something which we shouldn't take for granted. I don't think it's as easy as at least it may not be quite as easy as one might think. I did hear a tale. I won't embarrass the member of the judiciary who told me this tale, but someone had a go at a remote hearing where, well, essentially what happened is 5 people brought 5 laptops into the same courtroom. Each one turned on their Skype for Business with their microphone and their loudspeaker, and then discovered the concept of feedback. And that obviously wasn't going to work, and it got rather complicated. So there's a bit more to remote hearings than you might think, but in principle, they can clearly be done, and they will be done, and that's got to be the way forward. The final thing I want to mention is a slightly different point, which again is actually something Catherine Stevens mentioned. Being away from the office all the time is a problem, actually, and I think myself, we need to be realistic about that. One of the great things about the roles building, from a judge's point of view, is the collegiality. All the judges, more or less now, are on the same floor. All the High Court judges are on the same floor, and it is like being in a chambers or a law firm where we walk around sometimes and bump into our colleagues and talk about things and overhear other people talking about things, and you pick things up and you get a feeling for what's going on, and you get the opportunity to drop into your friend's room and chat about something and chew over a problem without giving anything away that you shouldn't give away, and that's part of the working life. And it doesn't really work using this remote thing. It just doesn't really work. And new people coming in, trying to help them see how things go, again, that doesn't really work this way. It's all just too stilted. And so even if only to allow people to interact with each other in a better way, we're all going to definitely have to go back into the office sometime, even if it's not 5 days a week. But I hope to see you all in the roles building sometime in the next 3 months. I'll be on holiday for 2 of those. Thank you.
Thank you, Colin. This business, I mean, I've done video links. I did a video link Court of Appeal case when I was presiding, so it must have been 10 years ago, a bit more, whenever that volcano went off and nobody could fly back. The council was stuck in South Africa. And I remember one of the things that you have to know, you make sure your picture's right. He actually won the case. It went on all day. So it was hybrid. They were the other side, were of course, there, wearing a gown. But it is important to get your camera right. He had a plant pot growing out of the back of his head the whole time. Like the first video hearing I did was in about 1989, something like the Trademark Registry. I remember what it was about. Somebody tried to register Glenlivet for water. I can't remember whether I gave it to them or not. But I wasn't comfortable with it because one side was in Cardiff. The hearing officer was in Cardiff, and one of the parties in the room, and the other one was somewhere else. It was a bit. Yeah. So now, Colin, I've got another question. I'm going to run a few of my own questions. I've heard some magistrates have said when it's a question of credibility, and you may not have had many, you don't get so many as magistrates do, everybody seems a little less credible on a video link.
Well, I mean, I think it's obvious that it's different. It's a different experience. I mean, I've also heard it said that because you get these very close facial close-ups, and maybe that's what the magistrate was referring to, that you see people much more. I mean, there is a sort of intimacy about this kind of thing which is different from a courtroom, and that's, I don't know whether that's well. I
mean, you might sound more credible wherever your camera is, because you see you're looking down at your screen. I can see that my camera's above my screen.
Yeah,
and that means I'm looking looking more at you.
But that's the thing. I think what that also connects into is this business of tolerance, because I would say over the last 3 months, it's noticeable, and I'm talking about myself, but also as far as I can tell everyone else, that at the beginning of it, the fact that the line of sight meant that no one actually was exactly looking precisely at you was really weird. And now it doesn't matter. We're all used to it. We're all used to the fact that people aren't actually looking exactly at each other.
There will be a patent application for a computer screen which has got the camera in the middle of it, but you can't see it, because then you will be looking directly at them all the time.
Yeah,
I've just invented that.
I think you might have disclosed it to the public, if I may say.
Yeah, well, I haven't. It's not an enabling disclosure.
I can get something filed today.
when you could just put in the details of how you do it. Anyway, a number of questions have come in. Now, I've got 4 knocking around. Well, a question which is really probably for those in firms: is there potential for London-based law firms to expand into national firms with staff based everywhere, so that you cease to be a London firm, but you're just a nationwide or possibly international firm? You don't have to be commuting distance to the office. What do you think, Catherine Wolfe?
Yes, well, as I said, geographical diversity is one of the things that we can expect from this. I don't know if that just because you've got staff and partners and consultants all over the place, does that make you a national firm? I'm not sure. I think home is where your base is, or where your bases are. Speaking for Bolts, we've got offices in London, Cambridge, Oxford and Reading, and people living in an area around that. Also offices in Germany and Spain, as I say. But does that make us a national firm in that sense? What is a national firm? What is an international firm? I'd say, well, if you've got an office in another country, then you must therefore be international to that extent. But there are other law firms that we know, other firms of patent and trademark attorneys, who have offices in many, many cities, right across the Midlands and all the way up into Scotland. And I think there will always be a difference between the people who have offices in different places and the people who just have people in different places. What do you think, Catherine Stevens?
Thanks, Catherine. Well, I would say, actually, in answer to the question, the present situation rather points in the other direction of not having national offices, because I think we've proved that people can work from home. And so what is the reason for taking on what could be a bit of an albatross around your neck in taking on expensive premises elsewhere? And I think that firms are going to be extremely nervous about that sort of capital expenditure going forward.
Right. I've just been told that the message has come through from Howard Reed saying, display with a camera in the middle of the screen has already been prosecuted at the EPO. It's been published. There we go. I think I've had a very important question from Emily Hudson at King's. She says, she's an academic. What are the longer term plans for vacation schemes, work experience, mini pupilages, and now the opportunities for undergraduates? Any advice or information we should be passing on to our students? Right, that goes to all the law firms and the bar. Gwilym?
That's really interesting. Just to go back to your comment a little while ago about the general patent attorney hiring plans, you're quite right that we have the famous demographic time bomb going back to 1978. But actually, I think the profession has learned quite a lot from that and realizes that because patents are recession-proof, you keep hiring. So I think a lot of firms are maintaining their hiring plans generally. Going to the specific area of work experience, mini pupilages and vacation schemes, like everything, we need to have a good think about how we're going to behave in the future. We clearly ought to be continuing to provide relevant opportunities to students at that stage of their training, of their career or their pre-career. If we are able to do it from an office space, then let's do that. But it doesn't seem very likely for a while. So instead, we have to look at I'm not allowed to call it the new normal at work. We have to call it the new weird. Apparently, that's strangely less painful for some reason. So in the new weird, I think the answer is that one applies for work experience, mini pupilages, and other vacation schemes. And then the people to whom you apply work out how you make that work in the new weird, and it will be weird. And that's actually that is one of the most interesting questions I've seen, actually, because I think lots of the other issues that are coming up can be solved because they're more day to day. This one is tricky, but I think we have to find remote ways of doing it, and we have to offer that for now.
Catherine Wolf, are you going to take a student who wants thinking about coming in, bright kid, and they want to come in the office for a week or so?
Well, I was actually going to turn this around a bit onto Emily Hudson, because one of the very, very interesting things about this is examination under Corona when everyone is at home. And I was very excited by this because everyone had been preparing for exams and then was told that, of course, it had to be done from home and therefore it had to be open book. And I thought it was very interesting because everyone had been, it was the best of both worlds, because you tried to learn it, so they'd had it in their minds as something to learn, which you will refer to for the rest of your life, but you won't actually be penalized for if you stuff it up when you're trying to write down, remember it, because it's right there with the tabs. So in that sense, for an examination, when it had come unexpectedly, I was quite keen on the remote examination. I really hadn't thought there was going to be. Also because the technology of writing an exam with a pen, people don't write anymore. They get cramp after an hour and a half, and an exam is traditionally 3 hours. People are used to typing. So again, that's something else that works better and differently remotely. But it's very, very...
Butt in there. That the only reason that we had handwriting is because universities are stupid. American universities haven't had handwriting for years. I mean, and you're right, not only can people not write, but nobody can read handwriting either. So that's going to be a good outcome, getting rid of handwritten exams.
Yes, I agree with that. There's quite an interesting thing in Brazil, the movie, where they try to write a check and only one person knows how to use a pen, which I always thought was quite a prescient clip.
Could I just add to this point? I think that I would advise students to really go for it, but what they might expect of a vacation scheme is going to be different, and really quite markedly so. It's going to be much, much more formal, with set interaction, usually one-to-many, being conducted by the firms. You are not going to pick up the soft skills that you would pick up if you were sitting in an office with a solicitor and just shadowing them. Nevertheless, I think it's still of vital importance that people actually do apply for these vacation schemes and do go for it. But I would say, think about those soft skills. How could you demonstrate when it comes to actually applying for a job that you are able to pick those up quite quickly? Is there other work that you can get which you might be able to demonstrate, with which you might be able to demonstrate that? So I think it is going to be more of a challenge for the students going forward. But I think everybody in the profession is aware of that and really wants to help them over it.
So, I mean, what would you advise somebody? I mean, thinking they wanted what they would have done before if they wanted to spend a little time at Bird and Bird, is they'd written in, and it would have gone to your personnel department, and somehow they'd have looked at the CVs, and someone said yes, and someone said no, and so on.
Yeah, and and that would be exactly the same. We have 2 intakes of summer students, and it's used as a good way of selecting our trainees. Those students who shine on the summer student program go forward to interview for the trainees. So it's important both for the students and for us, because that's how we get our talent.
Robin, do you mind? Can I say something about this? I mean, obviously, we don't take many pupils and trainees in the same way as the firms in the court, but we do have a judicial assistance scheme where young, usually post-qualified, but young lawyers, solicitors, and barristers come. And I've actually got one at the moment, and I must say I thought it was going to be awful because the person wasn't, normally what happens is they come and sit in your room as trainee solicitors would do, or pupils. But obviously we can't do that. But what we've learned to do between herself and me is actually get along pretty well, I mean, by doing the whole thing remotely. It actually does work. And I'm a little bit surprised by that. I didn't think it would work as well as it does. So, I mean, of course, she's not here to tell you what she thinks, but I certainly think it seems to work pretty well. So I think there's still plenty of scope for that kind of thing to do in this world.
Yeah, well, I used to take people. I just sort of I let the chambers when I was a new judge. People used to come and spend a little time. I had the two Toms with me for a week at the same time.
Right. Yeah. It can work. It does work. I mean, I really didn't think it would work at all, but actually it does. Because of course they can come to the hearing. It's no different, and all the rest of it. And you just get used to arranging, you know, the chat on Teams at 9 in the morning or something most days just to catch up.
It's a subject which is not confined to IP by any means, but confidentiality is a big problem for remote hearings, isn't it?
Do you want me to say something about that? Well, I say yes and no. The Skype for Business technology that the courts have tried to use mostly, and everyone says, oh, Skype for Business, it's old and it's not very good. But actually the great thing about Skype for Business is that the staff know how to do it, the judges know how to do it, the litigants have all learned how to do it, and it does work, and we can make it work. The one thing Skype for Business doesn't do is allow anyone to control people who come into the hearing if you'd already sent them the link that lets them in the first place. But what we've done for the times when I've actually had a hearing in private, actually proper private, using Skype for Business, is that one just makes sure that the solicitors normally keep an eye on the participant list, because the one thing you do know is who's come in. And if someone pops up that nobody knows, then you stop and wait until you've worked out whether they should be in the hearing or not. And if they're not, then my clerk can remove them. And what my clerk can't do is stop them logging in again, but then you just remove them again. And that actually seems to work really very well indeed. And so far I've done quite a few hearings now in private like that, and I'm not pretending it's a perfect system, it's not. The other thing is that if you have one of these expensive providers, which of course bigger litigants can do, but I'm not suggesting that modest litigants can do that, but the big battalions can do that, and they get some of these companies like Opus and Spark to do the hearing for them. They absolutely can control who's in the hearing, and you can do a private hearing completely because they know exactly who's in. I guess what you can never know is who else is listening in sort of behind the telly or behind the computer screen. But presumably, if the people you're permitting to join are all people that you trust, then that works. But that does seem to work.
May I add a bit about the EPO experience, which is that the EPO has shifted very successfully, I think, to video conference hearings as default for all examining division stuff. So the kind of the bread and butter work, and that seems to be extremely effective. It's still working out how to do especially complex oppositions by video conference because of the limitations of Skype technology, really. They have the same issues with access. Oppositions are open to the public, but that's done by invitation to stop people just kind of running in and doing moonies on screen and things. And in terms of the sort of bad behavior that Sir Colin's talking about, then they have a three strikes kind of approach. The other concern that was raised was the recording of proceedings. But realistically, a bit like everything else, if people were going to do that, they probably would have done it in real life as well. They just needed to put a phone in their pocket and stick it to record before they went in. So these issues seem to be being dealt with. Again, I think, as you said, Colin, by just getting on with it, getting over it, finding a solution to it. And so most of the time we do seem to be solving it. And by the way, I think that video conferences for X party of the EPO are brilliant, economic, and make perfect sense. And the proceedings work fine. It's a technical hearing, it works.
Yeah, I would say it's a good thing, recording. I mean, the EPO has always resisted recording anything. All continental courts seem to think it's a very wicked thing to take down what's happening in open court and have an exact record of what was said. and they produced a sort of summary of what was supposed to be said, like an old-fashioned policeman's statement. You put it across and sign it. It was ridiculous. Whereas we've recorded everything forever.
If I can
print up my entire career anyway.
A quick EPO nerd whinge, which is that now that in the Boards of Appeal you can't even introduce new arguments without leave, it's very useful to have an extremely good record of what you argued at first instance, so that you can show that it wasn't a new argument, and recording would solve that. But yeah, I don't think it's going to happen. It's just a comment.
Well, a sort of practical question which James Nerton has put in. What about fees? Is anybody getting any pressure on fees? Are people asking for reductions, discounts, moving away from hourly fees? Is anybody getting more pressure than there has been in the past on any of those things? Just a quick sort of yes or no, really. Catherine?
Yes.
Is it worse now than it was?
Well, you always do. I wouldn't say personally that it's worse than it was, but it's just a different reason. You know, it's the same proportion, but with a different reason, I would say. So far, but the time lag point, I think, which Catherine mentioned, I think is quite an interesting one. I think this has been an incredibly upbeat session, hasn't it? We've all been saying really good things, but I think that note of the time lag is something worth recalling.
Mm.
Yes, I would agree with Catherine on the fees. And, you know, it was standard to be asked to hold your fees for 2 years prior to the lockdown. And it's crept to 3. I had a cheeky one for 5 a couple of days ago. So I think what we're doing with some of our clients is just talking about different ways of charging, which sort of does move you away from the hourly rate, as I said in my 10 minutes. And I think that is also increasing, but we can engage clients more in that discussion.
Well, I wouldn't be sorry if hourly rate disappeared. I remember when it came in. It was invented by accountants. It is a completely useless system. It's like trying to measure the volume of a swimming pool by measuring one side of it. An hourly rate. I remember when the days when Herbert Smith was going to become the great advocates, and they came and said they were in order 14, and I had to see their bill, and they'd got 24 hours research on the principles of Order 14, Part 24 to you. and I disallowed the lot on the grounds they should have known it all already. But it does show that hourly billing is in fact in the wrong hands, actually a way of increasing costs. And I'm bound to say as a judge I found that, so maybe Colin did, I don't know. I remember once some application or other, they had all the fee earners. It was only an application, and they put a whole rugby team. I said it was a rugby team. 15 people they had on it. Some bloody application. I will not be sorry to see it go. What else we got here?
Robin, there was a point actually I just wanted to comment on, something that Mr. Justice Burst mentioned about equality of arms, and this idea that if we're going to have hybrid hearings, that there might be the point that the sort of the person, the same roles need to be doing the same, attending the hearing in the same format. And I've certainly had an example of a colleague who's had a hearing where one counsel was on the phone and one was doing it by video link, and the master hearing it was doing it by video link. And my colleague who was on the video link did feel that it was an advantage to him that he and the master were both on video link and the other counsel was just on the phone. And it's partly to do with the fact that you can read things from facial expressions. there's a sort of camaraderie that comes by watching each other, and sort of you respond to each other. So I think that's actually a very important point, that if we are going to do these hybrid hearings, that sort of equality of arms is quite important. And just the other thing in terms of hybrid hearings that I think is difficult is the issue of the electronic bundles, and the use of courtrooms for electronic bundles, because in my experience, the way electronic bundles really work is if you have sort of a bank of screens, and you can have various different windows open, and that's so you can have different pages of the bundle open on different screens. It's going to become more complicated if we're trying to use those systems in a courtroom, and everyone's got sort of, is everyone going to have 3 screens in a courtroom, and are these screens going to be moved in and out every time the court needs to be vacated? I'm sure there are ways around it, and I'm sure there are ways of doing it. Maybe everyone's going to use iPads or something to look at their bundle. But I just think there, it comes back to that all of this, it's potentially very exciting and liberating, but it is going to require an awful lot of thought as to how it actually is moved forward. I just thought I'd get in there. It's not particularly in response to a particular question, but there were just a couple of thoughts.
You're going to ask the last question, because we're nearly at 1/2 now. The last question comes from Diana Sternfield. What's it like to cross-examine electronically?
Well, I haven't actually had to do it in lockdown. I've done it with a witness on a video link, in a normal hearing, and it's fine. I mean, basically with advocacy, it's all about preparation. It's all preparation, really, and you can never be too prepared. And you effectively, with remote hearings in particular, you really have to be prepared, and you just have to be very conscious of the situation and how it's going to work, and it is fine. I mean, you just need to make sure everyone has the right materials. Nowadays with cross-examination, you're meant to, in terms of extra documents, you usually give them to the witness in advance anyway. Particularly if it's complicated scientific papers or whatever, they get them, you can't just spring it on them. They need to have read the paper to have a look at it. And you have to do that with remote hearings anyway. Certainly, as I understand it from colleagues who have been doing cross-examination, that there's a sort of an agreement that if there are extra documents to be provided to a witness, they're emailed, the morning before or whatever, and everyone has the document to work from. It's fine, it's a slightly different skill set, but you just need to be prepared. And that is what you have to do with advocacy. It's preparation.
So some things never change.
No.
Well, we reached the magic hour, and I'm going to go and open a bottle. I want to thank the whole team very much for coming. I hope, I'm not going to do clapping, it's damn silly, I've seen clapping. I just want to thank you all very much for coming. I hope you've enjoyed it as much as I have. It's been actually quite instructive. And I've been to a whole lot of video things. Grazian did one and so on and so forth. But quite a lot of extra things came out in this one, which weren't in the ones that have been gone before us. Thank you all very much. Get rid of your hourly billing. Keep on making lots of money and have a lot of fun.
Thank you.
Thank you all very much indeed. I'm leaving now.
Thank
Bye.
you.
Goodbye.